Right, good morning everybody and welcome to this de facto Monday after a long weekend. Fortunately it's a short week, right, and thanks for joining. See, we're all very keen on learning tax after the long weekend, so here we are. We have to keep on keeping on. We said this, I just said this morning, somebody has to keep the economy going. We can't all be on leave, so here we go. So today's discussion is a very important judgment in the context of tax dispute resolution, the case of Dr. Reed and Dr. Reed Inc. versus SARS. And it deals with this very basic issue of what is a valid objection that went all the way to the full bench of the High Court. Right, so I'm Nick Thornton. For those of you who don't know, founder of Unicus Tax. Please take note, for those of you joining online, this session is intended for my staff, and for those of you online, merely for your interest's sake. All right, so what is this case about, and why is it so important from a tax dispute resolution space? So let's start with the background. I'll take you through the case, and then I will give some criticism on the case, and then tell you what the practical takeaway is of this, because it does get quite technical fairly quickly. And I can debate the technical issues for eons on end. I wrote a whole article, have you guys read it? I know that you were all very keen last week looking for all my articles, and so you read all of them, huh? Yeah. So there's an article on the website as well for those of you interested in the technical side of it, but let's just get to the gist of it. All right, so the judgment was handed down recently, and this is an appeal against the tax court's dismissal of the taxpayers Rule 52(2)(b) application. And the question that was before the tax court, and indeed then what went on appeal to the High Court, was whether the taxpayer's second objection was valid in terms of Rule 7 and whether SARS was entitled to invalidate it. There are two things in life that annoy me. The one is a leaf blower, right, which is the one that's behind me now, and the other thing is a wheat eater. Right? Did you hear the guys when they wheat eat? They don't go zzz, they go zzz, 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 zzz. Anyway, I don't know who teaches them to do that. But anyway, all right. So let's carry on. That was appeal against SARS's decision to invalidate it. So we know that SARS can invalidate an objection. This guy's going to be famous. Any second he's going to come into shot with his leaf blower. Right, and this was not a final determination on the merits of the case. So be mindful of the fact that this was a kind of interlocutory application. It had to do with the validity of an assessment. What is important for context is that the dispute arose in the context of an estimated additional assessment, and I think this is crucial to this judgment, because I think people are going to misquote this thing. When we get to the detail, you'll get to understand it a little bit better. But right, so that's the background, a little bit of background to the case. Now, let's just quickly refresh your memory, because I said this is an application regarding the validity. So SARS had invalidated the objection. The taxpayer took it to the tax court on motion and said, I want to have it declared valid. The tax court said no, and the taxpayer went on appeal. So let's just understand what the issues are. So we all know Rule 7. Most of you, and I think those of you in practice, don't even read Rule 7 anymore, right? Rule 7 says you must set out the grounds for objection in detail, identify the specific amounts disputed, set out in detail the grounds for assessment, and submit supporting documents that's required to substantiate your objection, right? And if you don't comply with Rule 7.2, right, which is the thing that sets out those requirements, then SARS may regard it as invalid, your objection, in terms of Rule 7.4. Now, Rule 52(2)(b) is there to allow taxpayers to bring applications to the tax court to have SARS's decision set aside and have the objection declared valid. That's effectively what they're looking for, right? And this is a rule that I've used many times in practice to launch applications to have objections declared valid, because you often find that you submit an objection, SARS invalidates it for some invalid reason, right? And then you object again and they invalidate it again, so you get stuck in this never-ending loop. You might have seen this before for those of you online. And I have launched many a Rule 52(2)(b) application on the tax court, and in 99% of the times, SARS says, sorry, we'll fix it. And I've had ones where they tendered costs for me having to bring the application. And in one memorable case, the accountant that caused the issue was also sued by the client to pay my costs for bringing the application, because that was partly to blame for the issue. But anyway, that's the statutory framework and procedural framework. So we've got Rule 7 that says these are requirements for a valid objection. SARS can invalidate it if you don't comply, and if you're not happy with that decision, you can't object to that decision to invalidate. You'll have to bring a motion application to the tax court to say, have it declared valid. Also important is the assessment in this particular case was a Section 95 estimated assessment. right? And that's important to understand. It's an estimated assessment, right? And what Section 95 says is it says if SARS raises an estimated assessment, it doesn't take away your obligation to file a return or to submit relevant material. And I think this is crucial to this judgment, right? And then Section 102, of course, as we know, allocates the burden of proof or the onus of proof. It says who carries the onus. Most of the time it's taxpayers, but in the case of an estimated assessment, the onus of proving the assessment is reasonable is on SARS. And so we know we've got an estimated assessment here. So what did the High Court then decide, right? The High Court said no, the taxpayer's appeal is dismissed. The taxpayer should have submitted documents to support their objection in terms of Rule 7, because what the taxpayer was trying to do here is, or at least so the argument went, and it's quite ironic how the argument aligned perfectly with an article I wrote after the tax court judgment, almost to the T, but anyways, that's a discussion for another day, right? And I wrote, obviously, that article well before this judgment was handed down, so I don't know who relied on what, but anyway. So the taxpayers here took issue with the reasonableness of the estimate. And they said, and really just the crux of their argument, we'll get to it later again, the crux of the taxpayer's argument is I didn't have to provide supporting documents because I'm saying that SARS carries the burden of proof. And when I read Rule 7, it says if I submit substantiating documents, it must be documents to substantiate my grounds for objection when I carry the burden of proof. But when SARS carries the burden of proof, what documents must I give them? They ultimately bear the burden of proving. So it's that classic guilty man's defense kind of argument they were trying to advance to say SARS is put to proof. But the trouble is the High Court says is, hang on, when I look at your objection, you are not simply taking a SARS is put to proof case. That's not the case you're making out, because you did submit documents and make statements regarding the correctness of the assessment. So then you must provide the substantiating documents. If you're running a purely SARS is put to proof case, then run a purely SARS is put to proof case. But don't try and have your cake and eat it, right? And the reason people don't just run an onus of proof case alone is because it's not that difficult for SARS to prove reasonableness, to be frank. But anyway, let's move on. I might be getting ahead of myself. Right. Because the court held that because the taxpayer's objection did more than simply put SARS to proof, the taxpayer had to provide the substantiating documents required to substantiate those positive grounds, right? So there's a negative defense and a positive defense. A negative defense is SARS is put to proof, right? To say SARS, on the information available to you, your conclusion is not reasonable, or the information you had. That's a negative defense. A positive defense is the assessment is wrong because, look, here's the actual income for the year, or here's the actual expenses. And what the court said is, in this case, you did more than simply take a negative defense. You also challenged the correctness, and therefore you simply had to provide documents required to substantiate your objection. And the taxpayer had quite the point, and I agree with the taxpayer's point, which is what I said in my initial article after the tax court judgment. In fact, on the YouTube channel, the Unicus Tax YouTube channel, there's a whole video I made about Dr. X and Dr. X practice, is what the tax court judgment was cited as. But the court said, look, 102, insofar as it deals with onus of proof, is a red herring when it comes to this Rule 7 setting. And what does that mean? The court actually explicitly says that onus of proof is irrelevant at objection level, right? With which I respectfully disagree, right? And the reason the court says that is because that was the taxpayer's defense. The taxpayer said, hang on, if I am objecting to an assessment where I'm putting SARS to proof, right? I don't have to give any substantiating documents. I don't carry the burden of proof. So the taxpayer was trying to argue, or argued, that when you read Rule 7, in particular the requirement to add substantiating documents to your objection, you must read that in light of who carries the burden of proof. Right? If it's SARS that carries the burden of proof, why must the taxpayer provide substantiating documents? Right? If it's the taxpayer that carries the burden of proof, yes, then you must provide the substantiating documents. And so they say that when you read Rule 7 and interpret Rule 7, that's the lens through which you must interpret it, which is exactly what I said in my article following the judgment of the tax court. Shortly after the judgment of the tax court, I said that, and I published that publicly. And so that argument, it seems, somehow found its way to the High Court. Right? But anyway, I wasn't involved in the judgment in the case. Right, so the court said no. That's not the issue. We can't say that 102 determines the documents you must provide. But here the court makes an important point. It says the taxpayer in his objection identified a certain system, it's called the health bridge system, that contained material necessary to substantiate the taxpayer's grounds for objection, and they never gave SARS the access to the information. right? At one stage, and this is typical of certain taxpayers' attitude, where I'm not saying that's the case here, but you certainly get taxpayers who think they are too important to deal with SARS, right? So it seems here, and this was kind of those, it seems like this was one of those defenses where the taxpayer said, you can come on a Saturday morning, SARS. If you want access to my systems, come on a Saturday morning, or come at 12 o'clock at night. Almost as if to frustrate the process. You get that distinct impression that that might have been the intention. And then also, during the objection process, SARS said, well, let's pen this objection because I need access to the health breach system. You yourself said we need access to the health breach system. And they went out, and then there was nobody there at the taxpayer's premises to help SARS understand the system or give them access to the system. And SARS said, well, you made access available, but in terms of the TAA, I'm not allowed to touch your records without supervision. Right? So they were there, they were given access, but it seems like it was frustrated. It seems like SARS's efforts were frustrated. And the court says, look, in a situation where you've got an estimated assessment, right, where you have not given SARS the information on which you yourself rely to substantiate your grounds for objection, we can't say, no, SARS must just be put to proof, because that defeats the purpose. The court says, in fact, in the case of an estimated assessment, see, I think that's on my next slide. No, it's not. It says that in the case of an estimated assessment where you did not give SARS the information, you didn't comply with your obligations as a taxpayer, you can't simply run a SARS put to proof case, because can you imagine what will happen if that were to be allowed, right? So now think about estimated assessments, right? I think one can probably distinguish between the three types, 95.1 A, B, and C. But in the case certainly of an A, and I think in a B, but an A and a C case, you haven't filed your relevant material, you haven't filed a return. So SARS goes and they do an estimate, right, on the information available to them, which is crucial. It's on the information available to them at the time they make the assessment, not later, right? So if the taxpayer were to be allowed to say, no, I'm running a SARS put to proof case, then you can effectively ignore SARS, make them make an estimate and say, your assessment is not reasonable, without you ever complying with your obligation to file the return or submit the relevant material. Right? And that's what the court says. It says, no, your argument on 102 is, I think one must read it more carefully to say, in this particular case of an estimated assessment where the information wasn't available, is irrelevant. Right? And I think that makes sense. I think if you try and follow too strict an approach to this, you can comment on it to say, look, if this was a 95.1b estimate, that's where I've always had issues with section 95.1b, because unlike 95.1a and c, where it's clearly the taxpayer's fault, the taxpayer caused this evidential vacuum by not submitting the return or not submitting the relevant material. In the case of 95.1b, and I've had issues with this section since they started amending on section 95, said, because 95.1b says they can raise an estimated assessment if the taxpayer submits information that's incorrect or inadequate. And I remember saying to them, listen, who's going to be the judge of that? Who's going to determine if it's an adequate or incorrect information? That's why, by the way, that's why section 95.1b estimates are subject to objection from the outset, because they didn't have it like that. I commented at the time, said you can't put 95.1b as not being subject to objection. We're going to have a fight about whether or not it is adequate or incorrect. Just make it subject to objection. Right, so I think that in the case of the taxpayer giving information and the issues, the adequacy of it, I think that a slightly more lenient approach to Rule 7 is probably justifiable. I don't know on what basis this assessment was raised. That was the issue here. The tax court judgment seems to suggest it's 95.1b, but then also it depends on the information that was submitted to see if this was one trying to dodge his obligations to file. It's certainly on the basis of the information not being made available. It seems like that was the case. All right. But the biggest criticism I have against this judgment is the court explicitly says that section 102 is a red herring when it comes to objections, and it says that onus of proof is irrelevant at objection stage. I still disagree with that respectfully, right? Because if we do that, we could have a position where SARS is never called upon to discharge the onus of proof, because every time you file an objection, SARS will say, you haven't provided substantiating documents, invalid. Start again. File, invalid. Start again. File, invalid. Start again. And yes, we've got 52.2b, and the taxpayer did try to make this argument, but the court said, well, that's what 52.2b is there for you to bring this application. But I do think that if we're going to interpret this as even providing necessary documents always, even if you run a purely SARS put to proof case or a guilty man's defense case, we could sit with an issue where if burden of proof is irrelevant, SARS will never be called upon to discharge because they'll just keep on invalidating the objection, and the court will say you can SARS because the taxpayer didn't provide substantiating documents. You follow? So I think that the judgment is open to criticism at that level to say you can't say onus of proof is entirely irrelevant at objection stage, because that raises further questions as well. I mean, how often, let me ask you this, how often when we see additional assessments is section 102 quoted in the finalization letter? Always. Always. So SARS raises assessments on the basis of onus of proof not discharged, right? So why does that then mean SARS can't raise assessments in terms of onus of proof, because it's not even relevant at objection stage? So how is it relevant at assessment stage? It's even sooner. So with respect, I think that the court might have stated the basis for its refusal of this particular application too broadly. Having said that, I think that this judgment should be interpreted a little bit more contextual, because it's easy to read this judgment, and the court does say onus of proof is irrelevant, and it's a red herring. But we have to, when we interpret case law, interpret it for the facts of that particular case and in context. And when you read this judgment, I think that the court is not necessarily saying, although that's explicitly their words and I'm trying to find an argument here, but I think in context it makes sense, is I don't think the argument is that 102 is oops, what did I do? Wrong button. I don't think onus of proof is always irrelevant at objection stage. I think that in the case of an estimated assessment where the taxpayer caused, or taxpayer's failure to engage with SARS caused the estimated assessment, I think in that case you can't hide, if you will, behind onus of proof to try and, or to hide behind onus of proof to avoid having to discharge your obligation to give SARS information. Because like I said, you will then always, I mean, what stops the taxpayer then from saying, I'm just not going to respond, SARS is going to cock up the assessment because they can't do proper estimates, and they'll just raise onus of proof as a defense without ever having to comply with my obligations. And so the court in paragraph 64 and 65 of the judgment says that. He says quite contrary to what the taxpayer was trying to argue. He says that it seems like in the case of estimated assessments, there's a higher threshold for taxpayers to meet when it comes to disputing estimated assessments. And I think when you read it in that context, it makes a little bit more sense to me that the court is saying, onus of proof is irrelevant, right? And again, I stand by this point, is if you're going to make SARS's life difficult, those days are gone, people. I mean, I've sat with many a client where they would want to say, but SARS is entitled to do this, and SARS can't do that, and so I'm very important. I don't have the time to listen to SARS. We're all subject to SARS scrutiny, right? You can be, I almost said something else, you could be the president, right? Maybe that's, but you're subject to SARS scrutiny. I don't care if you're the best neurologist or doctor or cardiologist or tax specialist, whoever you are. You must comply. And trying to make SARS's life difficult by not giving them access to the records that they need to finish their work is counterproductive. Like this application, it seems to me, with respect, is counterproductive, right? The strongest point here is that the court says that I think it's in section 102, is not relevant in the context of particular estimated assessments where the taxpayer caused the evidential vacuum, right? If the taxpayer responded with SARS and engaged with SARS properly, then I think that's it's a different argument, right? Now, the point I wanted to make is, what does this all mean? Because I can keep you busy with Rule 7.2 for ages, and validity and onus of proof, and this 52 application, which turns out was a waste of time. Enormous, colossal waste of time. Because it's been how many years? The objection is still invalid, right? Now the taxpayer must go back and engage with the merits. How often have I seen cases where people have tried, and I'm not saying, look, I raise these types of arguments often enough myself, right? Procedural arguments. But if you really want to run this kind of narrow SARS is put to proof case, you must just think about the consequences of that for a second, because it is not that difficult for SARS to prove reasonableness. It is not a question of is the assessment accurate. It is also not a question of whether you can give SARS information after the assessment has been raised that prove the assessment unreasonable. That's not the question. The question is, on the information that SARS had, is it reasonable? Not correct, reasonable. And oftentimes you'll find that on the information in front of SARS at the time they raise, especially if a taxpayer doesn't respond and give SARS information, the Africa cash and carry case is a typical example, right? The assessment, it's not right, but it's not supposed to be right. It's supposed to simply be reasonable, right? And once SARS crosses that threshold, right, or shows that the assessment is reasonable, you have to deal with the merits anyway and prove the assessment wrong. So what's the point, right? What is the point of fighting this procedural fight for years in the tax court, and then after that in the high court, and then ultimately you have to deal with the merits anyway, which you were so trying to avoid by not giving SARS access to the health breach system. That's how it seems. And so there's a message to taxpayers in this, and I'm not trying to say, you know, there are arguments that you can make and defenses you can raise. But this SARS is put to proof argument is something that I've said to many clients before, is yes, we can run that defense. I can, because they sit here in the boardroom and they complain, and it's fair, that the assessment is ridiculous. Bank statement cases are the epitome of examples where SARS says, but these are all the deposits in the bank account, we want to tax all of it. And they raise those assessments in terms of 95, right? And then the taxpayer wants to, but that is ridiculous. That it can't be taxable in full. Right? I said, but did SARS ask you to explain it? Yes. Did you answer? No. So absent an explanation, is it reasonable? Not correct. Is it reasonable? And the answer is going to be yes. So why do you want to go down that road of saying, this is unreasonable, I don't want to engage with the merits, I don't want to explain the deposits line for line, if ultimately you're going to lose that battle? And ultimately you're going to end up having to deal with the merits anyway. So oftentimes you see when taxpayers deal with these cases, it's almost as if they don't want to engage with the merits of the case. Right? I often ask the question, why? Why do you not want to engage with the merits? Is it because you don't have any? Is that why? Or because you want to prove a point on a technicality? To what end? We have to be pragmatic about dispute resolution. Yes, I'm the first one to raise a technical point if there's one to be had. But you can't divorce technical arguments from the factual reality of a case. Because as soon as you do that, you're going to step into a hole, right? So I'm the first person to say, let's raise breaches of 42 and 96 and 92 and breaches of Rule 7 and all those. We'll raise them, but not on its own. Not divorced from the factual reality of the case, and not divorced from the fact that SARS ultimately does have the power to investigate taxpayers and to make assessments. You have to be realistic about it. Otherwise, what's the point, right? Don't raise them in these vacuums. You might end up getting nowhere. But like I said, I do think the court has set this a little bit too narrowly, or too broadly to say 102 is completely irrelevant. I don't necessarily agree with that. In the context of estimated assessments, maybe. Right? Maybe that's defensible. Right, like I said, it is oftentimes faster and more effective to just deal with the merits. It seems counterproductive because I know the bank statement cases, again, we deal with them, we've got several running at the moment, right? It is very annoying and very frustrating and indeed very time consuming to deal with those deposits line for line for line for line for line, right? I can see some of the faces are going, yes, we know, we're doing it, right? So it is annoying and it takes forever. But the alternative argument that I often see taxpayers to try and avoid having to go through that exercise is to put this reasonableness, right? Or to just do high-level calculations and make assumptions. What's the point? You're going to end up losing the case, right? And I know it's annoying, believe me, I know. But deal with the merits. Don't shy away from the merits. And here's a giveaway, a quick giveaway. People often profess to operate in the dispute resolution space, in the tax dispute resolution space, and some do, right? But one of the quickest giveaways to see if someone really knows what they're doing is to test if they engage on the merits or simply engaging in this fluffy procedural stuff. I can talk for ages on procedural stuff with you, but what is the substantive merits? What is the tax issue about? Is it the 11A issue? Where is the issue in substantive tax law? We can't avoid that. We're going to have to deal with that. And so if you engage with someone, I read an objection the other day. It was this thick, right? And after I read through with someone else, I won't mention who, I won't even say what it rhymes with, right? So I read through this thing, and the client I saw the client shortly after that, and I said to the client, I read through all 50 pages of objection. I have no idea what this case is about. No idea. Because whoever wrote this thing is just refusing to engage with the merits. I don't know what the numbers are. I don't know what numbers they are disputing. I don't know what evidence they're giving for disputing. They say a lot of things, many things. Smoke and mirrors is what it is, because they don't engage with the merits. And that's often for me a key giveaway that the guy dealing with it either knows there's no merits or doesn't understand what he's doing, right? Because he's shying away from the merits or she's shying away from the merits, right? Point is also practical takeaways. We can talk about the procedural stuff again for ages, but the takeaway is just deal with the issue head on and take note that an objection is a legally technical document. I mean, this is a case about Rule 7.2. The section or the rule I said earlier that very few people actually still read. In fact, I would venture to guess most people who file objections don't even know there is a Rule 7.2. They just know there's an NOO form that they must complete, right? When in fact there's a rule in the tax code rules that regulates that thing and what must go in there. And in SARS's defense, I think the forms does kind of force you to comply with that requirement, or tries to, but it's very easy to break that rule. And indeed, in this case, it costs the taxpayer dearly because now, how many years later are we? Yes, the procedural application will suspend the periods to lodge an objection in terms of Rule 54. I can talk about the technicality for ages, right, and the proceduralness for ages, but now it's 2 years later, now we have to go back and deal with the merits anyway. Why? Just get it right the first time around so that we don't end up with this issue. All right. Excuse me, that's not to say don't ever run a SARS put-to-proof case. Right? There are instances where you can run that. Because there are instances where I've looked at the assessment, I go, hang on, my friend, how did you get to that number? That doesn't make sense. Even on the information in front of you, that number doesn't make sense. But even then, it is hardly ever a clear-cut, there's no way they can discharge the onus of proof. Because you run that risk if you run that sort of defense. Because if that's the only basis on which you're running your defense and SARS succeeds, you're dead. Right, the case is over. SARS has proved the assessment reasonable, you lose. Go back and try again. Well, you can't because then the assessment is final, in fact. Right. Key takeaways, right? You have to deal with the merits, right? Because you'll find that if you don't, the merits might never be decided because SARS keeps on invalidating the thing, right? Just deal with the merits head on. I know it's frustrating, but it is what it is. That's what the High Court has now said, right? And also, because the High Court has now said, in so many words, that 102 is irrelevant at objection stage, until a High Court, I think, intervenes and explains that that's not the context in which you must read it, I think SARS are going to raise it as a defense to say, you must provide substantiating documents. And if you don't, we just declare it invalid because, and if it's invalid, you end up in this loop where your objection is never decided, right?